In this video I want to take a look at a very interesting decision issued there a few weeks ago by a judge in the High Court, Mr. Justice Toomey, I think his name is. The case is, well, it's very, very interesting because it deals with a number of issues, including unqualified legal advisors, who the High Court judge has described as malevolent, lay litigants and McKenzie friends. So it's a case that's well worth a read. The decision is, as I say, published. It's on the High Court website, but I will put a link to the website or to the decision underneath the video on my YouTube channel. You can have a look at it. It is a case involving lay litigants and repossession of property and so on and so forth. But the comments made by the judge are very, very interesting in relation to unqualified legal advisors. So let's have a look at that. I'm going to scroll through it here and I'm going to pick out the bits that I think are interesting and worthy of note. So let's have a look there now. So the case involves Teresa Barrington and Sean Harrington, and they are the plaintiffs, and they named in their case, in their litigation, the Attorney General, Táilte Éireann, who is basically Land Registry, Promontoria, Oyster DAC, David O'Connor, BDO and MRCS Limited, and Paul Garvin. So there's a lot of defendants named there, and this is one of the significant catastrophic mistakes, quite frankly, that the lay litigants made. But in the first instance, let's just take a look at what the judge has to say. He says, and some of these paragraphs are actually worth reading out word for word, quite frankly, because the comments are worthy of note. So let's have a look now. First few paragraphs. It seems clear to this court that it would not be tolerated if quack doctors, that is, people who are not medical practitioners under the Medical Practitioners Act 2007, were walking around our hospitals giving pseudo-legal advice to patients in hospitals when those patients are at their most vulnerable. It seems equally inconceivable that operating theatres would be occupied as a result of unnecessary surgery being performed on the medical advice of these quack doctors, causing other patients to have their surgery delayed. So he makes a comparison there with people relying on quack doctors, for example. He says in paragraph 2, yet the equivalent is happening on a daily basis in our courts. This is because litigants are having their cases delayed as court sittings are being taken up dealing with nonsensical applications which are being pursued on the pseudo-legal advice of people who are not legal practitioners under the Legal Services Regulation Act 2015, and so are quack lawyers, or as Noonan J described them, hob lawyers. These unqualified litigation advisors are giving this legal advice in inverted commas on a daily basis in our courts to lay litigants when they are at their most vulnerable, since they face serious litigation. This issue arose in this case because the plaintiffs, the Barringtons, are being assisted by an unqualified litigation advisor in relation to their dissatisfaction with a High Court decision which rejected their application for an injunction regarding a property in Galway. However, rather than appealing that decision to the Court of Appeal, they brought an application to another High Court judge to reverse the decision of the first High Court judge. Even to people with no legal expertise, this would be a nonsensical application to make, since one High Court judge does not hear what in effect is an appeal from another High Court judge's decision. As a result of this nonsensical application, a full half day in the High Court, which could have been used to deal with other cases, was wasted dealing with an application which no legal practitioner would have brought. For this reason, this case starkly highlights not just the harm to lay litigants, but also the systemic harm which has been caused to the administration of justice by the significant number of unqualified litigation advisors who are practicing, in inverted commas, in our courts. So that's the first 4 paragraphs of the decision. As I say, the decision is well worth reading. I'll have a link in it in my YouTube description on my YouTube channel. He goes on then to remind us that a criminal offence for an unqualified person to give litigation advice. So basically, it's an important backdrop, he says, to this issue, is that it is a criminal offence for unqualified people to give litigation advice. And this was highlighted in Start Mortgages Limited versus Vincent Kavanagh and Madeleine Kavanagh, where Noonan J. referred to the disastrous consequences which arise when a litigant seeks advice from an unqualified litigation advisor, but also the criminal offence which is committed. He says it is not without good reason that the legislature has made it a criminal offence for unqualified persons to draft documents for use in legal proceedings for reward. This decision then of Toomey's goes on to say that the courts have been highlighting the problem of unqualified legal advisors for years, and he makes reference then to the case Bank of Ireland, Mortgage Bank versus Martin. Noonan J. stated, "Without exception in my experience, these groups and individuals cause significant harm to those they purport to assist by giving them advice which is not just wrong but entirely detrimental to the litigants' interests." Similarly, in O'Hara versus Ireland and others, O'Moore J. went on to say, amongst other things, the nature of these cases suggests that these are unscrupulous people availing of the credulity of lay litigants and encouraging them to launch claims which, legally at least, make absolutely no sense. He goes on to say there, as you can see and highlighted, bolded rather, however, the ill effects of this pressure are felt not predominantly by judges, but rather by litigants. It's a matter of some regret that the persons who are peddling this form of claim to litigants who do not have the benefit of professional representation have not yet themselves been made accountable for the pointless legal costs and expenses which their activities have generated. So he makes the point then, Toomey does, that unqualified legal advisors are not held accountable for the damage that they are causing. He refers then to an English case he refers to unqualified litigation advisors being referred to by Smith J. in Toomey versus Mallow Town Council. And in that case, Smith J. said, and you see it in bold, the courts do not require McKenzie friends. Now, this man goes on, there's an English decision then where the English Court of Appeal case of Orr versus Leicester City Justices, Lord Donaldson stated, "May I end by expressing a fervent hope, it is that we shall hear no more of McKenzie friends." Now, Toomey doesn't go that far, because he does make a clear distinction between a McKenzie friend and an unqualified litigation advisor. And he goes on to say, an unqualified litigation advisor is not a McKenzie friend. So a McKenzie friend, a true McKenzie friend, he says, is usually a pre-existing friend or a relation of a lay litigant who is in court solely to take notes or to hand up books or papers to the lay litigant. He or she does not provide any litigation advice or advice on the drafting of documents for the proceedings, for, as I already noted, this would be a criminal offence. In this way, a true McKenzie friend is akin to a person sitting in with a family member on a hospital visit or procedure to keep that person company, but not to provide medical advice. So there's a clear distinction being drawn here by Toomey between a McKenzie friend, a real McKenzie friend, and an unqualified legal advisor. In this other case, this Cuniff versus Cuniff, the appellant suggests that the court took a very negative view of her having a McKenzie friend to assist her. That is incorrect. Unrepresented litigants are entitled to be accompanied and assisted by a McKenzie friend. My point, the judge said, was that it is undesirable that persons who are not professionally legally qualified should hold themselves out as litigation or legal consultants. Lay litigants, then, Toomey says, suffer huge harm as a result of unqualified legal advisors. Unqualified litigation advisors also cause systemic damage to the administration of justice. Firstly, they cause a drain on court resources. As noted by O'Moore J. and O'Hara, it is other court users who are suffering as their cases are delayed. Secondly, they inflict a cost on innocent third-party individuals and entities who are unlucky enough to be involved in litigation with them. Those third parties will have to pay lawyers to deal with these nonsensical applications, and there's no guarantee of their costs being recoverable from the lay litigant, even if they get a costs order in their favour. And thirdly, unqualified litigation advisors inflict unnecessary costs on the taxpayer, because the state is invariably a party to these cases, and sometimes, as in this case, a state body is accused of being part of a conspiracy against the lay litigant. In fact, in this case, two state entities, the first and second defendant, had to incur, that's the Attorney General and the Land Registry, Táilteann Éireann, had to incur completely unnecessary legal costs because they were served with a motion which no legal practitioner would have served on them, since, as noted below, no relief is claimed against those two state defendants. Toomey goes on to say there and makes the remarkable statement that litigants are invariably better off with no legal advisor than an unqualified legal advisor. And he says, or Nolan J says, in the earlier hearing in this particular case in June 2024, his decision, if this case does anything, I hope it highlights to the Barringtons and to other people the danger of listening to malevolent actors that these third parties, unqualified litigation advisors are, who I've no doubt are attempting to stir up trouble for their own ends. Unfortunately, that does not seem to have worked in this case, since the Barringtons, in the hearing before this court, continued to receive assistance from their unqualified litigation advisor, and that man was a man called Mr. Michael Mackin. In summary, therefore, this application, in which the lay litigants were assisted by an unqualified litigation advisor, was one which served only to waste court resources and inflict unnecessary costs on the lay litigants, and also unnecessary legal costs on other private citizens and entities, as well as on the taxpayer or the state. And as there's no guarantee that these legal costs will be recovered from the Barringtons, this case therefore perfectly illustrates that the presence of unqualified litigation advisors in our courts leads to there being no winners but only losers. The only party who would appear to be not to be out of pocket is the unqualified litigation advisor. In this case, he looks at, Mr. Justice Toomey looks at the background to this case. There was an order made by Mr. Justice Nolan in June 2024 that was being the Barringtons were looking to have set aside. The order was for possession of their property because they had been unable to pay their loan and so on, and there was repossession proceedings and so on. The Barringtons then made an application to set aside the order of Mr. Justice Nolan, and they made it to the High Court, even though that's not the correct procedure at all, because they should have gone to the Court of Appeal. He makes the point here, the judgment of J. Nolan, which the Barringtons want to set aside. The plaintiffs seem to think that by calling their application a constitutional injunction, they can somehow or other avoid the rules of court. She is mistaken. Any application that comes before the High Court must be supported by an affidavit, setting out the facts upon which the party relies fully. In this case, there's no supporting affidavit setting out the facts. He goes on to say then, it's clear that folio records on the 23rd of September 2003, the plaintiffs were the registered owners of the property. However, on the 29th of December 2022, a year and a half ago, the sixth named defendant was registered as full owner. The law relating to the land registry is clear. The register is conclusive unless there's proven fraud or proven mistake. There is nothing before the court to suggest any fraud or mistake. And he says, therefore, since the register is conclusive, the plaintiffs are not the owner of the property, the sixth named defendant is. The Barringtons also allege that the state or other bodies are involved in some form of illegal activity in the form of conspiracy or fraud in an attempt to deprive the citizens of their constitutional rights. They generally have little or no evidence to support the contention, no matter how serious it may be. He says, having sat on the Chancery side since I've been appointed, it is clear to me that people who have found themselves in financial difficulties, generally arising out of the crash of 2008, have fallen into the clutches of a group of individuals who are taking advantage of them, misleading them for their own ends and acting as a form of legal advisor, perhaps for reward, when they are nothing of the sort. If this case does anything, I hope it highlights to the Harringtons and to other people the danger of listening to malevolent actors that these third parties are, who have no doubt are attempting to stir up trouble for their own ends. In this case, there was no evidence whatsoever before me to make any order of any description. The plaintiffs were given the opportunity to amend their hand, but they refused to do so. Before considering the law setting aside the judgments, it's important to note that Nolan J. referred to the dangers of lay litigants seeking advice from people who have no legal qualifications. He made the following comments. If you are listening to a McKenzie friend or your gentleman who is beside you, they're misleading you. I will not have the court's time wasted with a pre-written mantra when we need to just simply get to the point at issue, and that is whether the parties have a right to seek possession of the property. He says, generally arising out of the crash of 2008, it's clear to me that people have fallen into the clutches of a group of individuals who are taking advantage of them, misleading them for their own ends and acting as a form of legal advisor, perhaps for reward, when they're nothing of the sort. I hope it highlights to the Barringtons and to other people the danger of listening to malevolent actors that these third parties are, who I've no doubt are stirring up or attempting to stir up trouble for their own ends. And in this case, the person, he has been named, is Mr. Michael Mackin, assisting the Barringtons in this litigation. He says, the judge says, I understand that Mr. Michael Mackin has assisted Miss Barrington during these proceedings, although I do not believe he is qualified to provide legal advice. Similarly, at a hearing before this court, during which Mr. Mackin was sitting beside the Barringtons, counsel on behalf of Mr. Garvin made uncontroverted submissions in a clear reference to Mr. Mackin that the Barringtons were being driven by him to make their nonsensical claims. And again, these submissions were not contradicted by Barringtons. In summary, therefore, the court was provided with judicial statements, sworn evidence and submissions, none of which were challenged or contradicted by the Barringtons, to the effect that Mr. Mackin, although not legally qualified, is assisting the Barringtons with this litigation. The judge goes on then to acknowledge that many citizens cannot afford legal representation for everyday disputes like this one over the ownership of a small business premises, which are required to be heard in the High Court. This is because costs are prohibitive and the laws require so many everyday disputes to be conducted in the High Court, the most expensive trial court, where costs can be in the hundreds or tens of thousands of euro, rather than in the circuit court, where costs can be in the thousands of euro. The judge goes on then to say that in this case the Barringtons are asking one High Court judge to set aside the decision of another High Court judge. He says that can only happen in very limited circumstances where you can show fraud or the like. And he says there's no special or unusual circumstances in this case to warrant any setting aside of Nolan Jay's decision. The administration or the finality of proceedings is of fundamental importance to the certainty of the administration of law and should not be likely be breached. He goes on then to point out the sense of injustice felt by the Barringtons that led to this application, and he acknowledges that the Barringtons have felt a deep sense of injustice and appear to believe that they're entitled to have the order of one High Court judge set aside by another High Court judge because they did not obtain the right or just decision. However, that is not what is going to happen here, because the judge says that a judge, or a litigant rather, is not entitled to the right decision. The reason the Barringtons have obtained justice, he says, despite not getting what they believe was the right or just result, is because while superficially it may seem surprising to say it, litigants are not in fact entitled to the right or a just decision of the court. This is for the simple reason that there's no such thing as one right or one just decision. This is because different judges will reach different decisions on the very same facts. And this was put by the Chief Justice of Northern Ireland. She stated that there's a discipline to providing judgments. Colleagues might disagree with you, other courts might disagree with you. That doesn't mean you're wrong necessarily. It means that there are different views. And this highlights an important point, namely that just because one judge makes a different decision from another judge does not make one decision right and the other decision wrong. They're just different decisions from different judges. He goes on to say there, interestingly, the fact that different judges reach different decisions, while it might superficially appear to be a negative, is in fact a positive aspect of the administration of justice of Ireland, or in Ireland. This is because the Constitution requires all judges to be independent in the exercise of their judicial functions, and it's a clear sign that there's an independent judiciary if judges reach different decisions. This is evidence of the fact that judges are not subject to groupthink, but rather make up their own minds independently, that is, independent not only of the legislature and the executive, but also of other judges. So he says that there's no such thing as one objectively right or just decision, is vividly demonstrated or illustrated by the case of the Minister for Justice and Equality, in that case, versus Shuka. The applicant won his case, even though a majority, 5 out of 9 of the judges who heard his case, found against him. 1 in the High Court, 3 in the Court of Appeal, and 1 in the Supreme Court. However, since 4 out of the 5 judges in the Supreme Court found in favour of the applicant, he won. This case, therefore, is a stark reminder or highlights not only that different judges reach different decisions, but more importantly, there's no such thing as one objectively right or one objectively just decision to which a litigant is entitled. In this case, the Barringtons got a reasoned decision from Nolan J on the day of the hearing, and if Nolan J had failed to give any decision, the Barringtons would have cause for complaint, as would Mr. Garvin, as he would have been subject to the interim injunction until Nolan J gave his decision. The fact that the Barringtons believed that they did not get the right or just decision, and so did not get justice, is not a basis for that decision to be set aside. So, submissions of the Barringtons regarding their entitlement to set aside the order. The Barringtons claimed that there was several irregularities with the order and that Nolan J did not comply with the law in reaching his decision. In particular, they claimed that he did not comply with the Constitution, did not comply with case law of the High Court, and did not comply with the case law of the Supreme Court, and that he did not follow the rules of the superior courts, and that he breached fair procedures. All these grounds are the typical grounds one sees for the appeal of a decision, yet, as already noted, the Barringtons have chosen not to appeal, but instead applied to one High Court judge to set aside the judgment of another High Court judge. However, the more striking thing about this litigation is the number of costly errors made by the Barringtons while being assisted by an unqualified litigation advisor. So the errors, he goes on then to look at the errors made by the Barringtons in pursuing this application. Firstly, they served their application for an injunction on the wrong parties. Then they applied to set aside the original order and they served that on the wrong parties. Then they didn't swear any facts. They didn't provide any facts to support their application. They just provided law or legal arguments. But you need to swear facts on affidavit. They didn't do that. And they were directed by the judge to do that, and they ignored them. So Nolan J at the hearing in 18th of June 2024 says, "So, you set out in your affidavit the facts, not the legal submissions." He was giving them a steer there. They didn't take it. The Barringtons then ignore the helpful suggestion of Nolan J. So Nolan J also said to them, "So would you not consider my offer of putting the matter back so you can put it on affidavit? Mrs. Barrington, I can do no more than advise you as to what you should you do. Maybe I'm going beyond, so if you still want to proceed with the matter, I'll hear you." And the Barringtons refused to take up Nolan J's suggestion and instead insist on Nolan J deciding their application. And so, without any meaningful evidence or facts, it was fatal to the prospect of them obtaining an interlocutory injunction. In simple terms, he says, there was no way Nolan J could grant an injunction preventing the registered owner of the property from seeking possession of that property without any evidence which would support the granting of such an application, such an injunction. So Nolan J, the judge in the High Court in June 2024, was trying to steer them in the right direction, and they ignored him and went with the advice of Mr. Mackin. The Barringtons then ignored the helpful suggestions of Barneville P. So Toomey goes on to say, unfortunately, this was not the only occasion when the Barringtons refused to take up a suggestion made by a judge who was seeking to assist them, because when they appeared before the President of the High Court seeking to set aside the judgment of Nolan J, the President pointed out that they were within time at that stage to appeal Nolan J's judgment. He pointed out that this was the normal or proper route to take when a litigant is unhappy with a decision, rather than the unprecedented application they were making for one High Court judge to set aside the interlocutory order of another sitting High Court judge on the basis of alleged errors of law, rather than any change in circumstances. Inexplicably, they chose not to take up this suggestion from the President of the High Court, and whether on the advice of Mr. Mackin or otherwise, they pursued their application to set aside Nolan J's judgment, with the consequence that the time for making an appeal to the Court of Appeal has since expired. Some of the grounds then for set aside are nonsensical. For example, one of the reasons they put forward for setting aside the decision of Nolan J was the sitting of the solicitor for the Chief State Solicitor's Office as far away from the bench as possible, to be as close to the door as possible. This is plainly nonsense. Where a solicitor happens to be sitting in court is not a ground for anything, let alone a ground for one High Court judge to set aside a judgment of another one. The Barringtons misunderstand standard legal language. They received a letter. Please note that if you fail to deliver up the vacant possession of the premises within the specified time frame, then our client will, without further notice to you, take whatever steps may be available to it to secure vacant possession of the premises, including but not limited to obtaining peaceable possession of the premises. The Barringtons claimed to this court that they believed that the reference to means other than peaceable possession was a physical threat, thereby justifying their obtaining an interlocutory injunction preventing Mr. Garvin MRCS taking possession. This claim is based on a failure to appreciate that this wording is standard in such letters. It's a standard solicitor's letter and does not constitute a physical threat. It is simply a reference to the fact that if the Barringtons fail to give up the property, that is peaceably, then Mr. Garvin will be forced to seek non-voluntary methods. The Barringtons then misunderstand standard court procedures. The conclusion then that Toomey comes to: from all of the foregoing, it's clear the Barringtons have made numerous errors while being given assistance by an unqualified litigation advisor. As a result, they've missed the opportunity to adjourn the interlocutory hearing in order to put facts and evidence before Nolan J. They missed an opportunity to appeal the judgment with which they were unhappy, as had been suggested by the President of the High Court. They pursued an unprecedented set-aside application as a form of appeal to one High Court judge of another High Court judge's decision, which is completely unsustainable. They based that application for set-aside on some nonsensical grounds, such as the position of the seat occupied by a solicitor in court. They exposed themselves to thousands of euro in legal costs by wrongly serving 2 separate motions on 5 parties, and they forced the taxpayer to incur unnecessary costs by wrongly serving the motions on 2 state entities. The conclusion: this is a case in which there were judicial statements, uncontroverted evidence and submissions that the Barringtons were being advised by someone who has no legal qualifications. It's inadvisable for litigants to pursue costly High Court litigation based on such advice. In this case, the Barringtons, while being assisted by an unqualified litigation advisor, have made several fundamental errors in their attempt to challenge the order made by Nolan J, such as including legal submissions and effectively no facts in their affidavits, refusing to take up Nolan J's suggestion that they seek an adjournment of the hearing before him to enable them to put some facts and not just law before the court, refusing to take up the President of the High Court's suggestion to appeal Nolan J's decision to an appellate court rather than, in effect, trying to appeal the decision of one High Court judge to another High Court judge, and serving the motion for the interlocutory injunction and the motion to set aside the order on 5 parties who had nothing to do with that application. These have been costly errors, and it's the court's provisional view that not only Mr. Garvin and MRCS, but also the other 5 defendants are entitled to their costs. This is because, firstly, Mr. Garvin and MRCS have been entirely successful, and secondly, because there was no basis for the other 5 defendants to be served with the motion, which necessitated them incurring costs. So that is the situation there. As you can see there, the likelihood is the appeal is going to go, or the cost order is probably going to go against him as well. He's made that fairly clear, and this is a fairly excoriating judgment in relation to unqualified legal advisors, lay litigants, McKenzie friends, and so on. And I think it's a decision that's well worth reading. It's 34 pages, but it's an easy read. It's easy enough to follow along, I think, and I think it's worth a read if you have an interest in law. And it's a warning about lay litigants being taken advantage of by unqualified legal advisors who the High Court, Toomey and a previous High Court judge have described as malevolent actors. Hope you liked the video. Hit the thumbs up button down below if you do. Thanks a lot.